everyone. Welcome to our second PowerPoint presentation having to do with agency law. As I mentioned, in this PowerPoint, we're going to explore the second issue, which is when can someone, a plaintiff in a lawsuit, hold a principal liable for the actions of their employees in a lawsuit, just like the Sugarman car accident example with the Sugarman Bakery and Mo from the first PowerPoint presentation. So when it comes to talking about whether a principal is liable for the actions of their agent, we can talk about it for both contract liability and tort liability. Both are discussed in your book, and I'm going to focus more on the tort liability in this PowerPoint, just because I think it's a little bit more complicated to understand, but I do want you to also know when a principal is liable in contract for the actions of their agent. And what we mean by this is that sometimes we ask our agents or our employees to enter into contracts on the principal's behalf. So the question is whether that employee or that agent has the power to bind the principal when he signs a contract on behalf of the principal. And the question that the courts ask when that question comes up is, did the agent have the authority to act? So we break down authority into these categories listed here. When the principal gives direct, or in other words, express permission to the agent to act, well, then that employee does have the authority to bind the principal to contract. We call that express authority. The authority could also be implied, like if we know that the agent has a particular job to do and doing that job requires a signature on a contract, that type of authority would be applied. Those are the easier of the two. The more difficult questions about binding a principal to contract liability have to do with something called apparent authority and ratification. Apparent authority asks from that third person's perspective. So again, let's say I own a company and I hire my agent to do some work on my behalf. If the agent goes off and represents to others that he's signing contracts on my behalf, even if I didn't give him authorization to do so, if that third person that he's entering into a contract with would reasonably believe that this agent is acting on the principal's behalf, that is sufficient authority, even if that authority didn't ever actually exist. We call that apparent authority, again, from the third person's perspective. Lastly, an agent's actions can be ratified. Ratification actually comes up in quite a few areas of the law, and it would go like this. I'm the principal. I give the agent some authority to do some actions, but I don't give him authority to enter into contracts. But then the agent does enter into a contract, and I learn about it, but I don't expressly deny it or say, no, don't do that, or no, we didn't mean to enter into the contract. And I accept the terms of the contract and I move forward in my actions. By not negating that contract after I receive knowledge of it, my actions as the principal have ratified that contract, and I can't back out of it later. So those are the types of authorities that I want you to know for contract liability, for when a principal is liable to a third party on contracts signed or entered into by the agent. Okay, now let's move on and talk about tort liability. Now I wrote a lot on this PowerPoint, so feel free to pause it and read. Here's the rule. An employer is liable for physical torts, like the personal injury ones, negligently committed by an employee acting within the scope of employment. So I want you to pause and read that carefully. And I also want you to think back to the Sugarman Bakery delivery car example from our first PowerPoint. So the question would be, would Sugarman Bakery, the employer, be liable for the physical tort, that is the car accident with the Sally driver, who was, when that car accident was negligently committed by an employee, Mo, who was acting within the scope of his employment. That is the rule. So the rule is that an employer is liable, that is on the hook for when their employees act negligently within the scope of their employment. The legal phrase for this is also something called Respondeat superior. That's what this rule stands for. There's two parts to this rule that need to be answered. First, we need to figure out if the agent was an employee. Notice that this rule uses the words employer, employee. And we talked about how employment is agency. If you are working and you're the employee, you are the agent, and your supervisor is the principal. But we have to answer whether the agent is an employee. That's question number one. And the second question we have to answer is, was that employee's actions in the scope of their employment? So I'm going to define both of those terms for us, because if both are met, then the employer is liable. Okay, so part one is the agent and employee. This analysis requires us to know the difference between an employee and somebody who's an independent contractor. So we just finished our unit on employment, but I want you to also think about, in your context as an employee, are you an employee or are you an independent contractor? The law is not going to tell you, usually your supervisor, we don't always know if you're an employee or an independent contractor until there's an actual lawsuit. If you are an employee, you are likely, I should say it this way. You are more likely an employee the more control your supervisor or employer has over your employment. For example, does your employer tell you what hours of the day you have to work? Like your shift is 9 to 5 or 12 to 8. Do you bring your own tools or materials to work, or does your employer provide you with them? Your own tools, their own computer, their truck to drive? Are you working an hourly rate or a fixed price? And then, do you believe that you are an employee? But I really want to focus on the first parts, which is the part about control. The more control your employer has over your hours and your working conditions, the more likely you're an employee. An independent contractor more likely sets her own hours, uses her own delivery truck, uses her own tools and materials, and determines more about the day-to-day working relationship. The reason this is critical, the reason it's important as our discussion here, is because if you are an independent contractor, so let's say I'm a delivery driver, but I'm an independent contractor because I make my own hours and I'm driving my own truck, and my employer doesn't have as much control over my working conditions. Think Uber driver or Lyft driver. If I'm an independent contractor and I commit a tort, if I get into a car accident, guess who's liable? Well, me, the independent contractor, but not my employer. Because I'm an independent contractor, it would cut off that liability. But if I was an employee, if I mow and I'm driving Sugarman's truck and Sugarman gave me the truck and gave me all the tools and set my fixed hours, and I'm an employee and I get into a car accident, Sugarman's Bakery is on the hook also as the principal. Okay, so that's point number one, employee or independent contractor. This is basically what I just said. A principal might be liable for the torts of an employee, but is not liable for the torts of an independent contractor. That's just a restatement of what I just said. All right, what about the second part? This is really tricky. This is called scope of employment. So the employer or the principal is only going to be liable for torts that are committed during the scope of the employment. So I want you to think of scope of employment as not just the working hours, because just because it's 9 to 5 and you're on the clock doesn't mean you're acting within the scope of employment. For example, if you take a lunch break between 12 and 1 and you decide to run errands with your own car on your lunch break and you get into a car accident, are you acting within the scope of your employment? No. But if on your lunch break your boss asked you to do a task while you were out, are you now within the scope of employment? Probably. So scope of employment is not just about what hour of the day it was. We look at the actions the employee was taking or the agent was taking. Are they ones that would usually be taken during working hours, during doing the work that the employee is usually responsible for? That's what we're talking about with scope of employment. I'm going to give you a few tricky examples of scope of employment. Okay, so let's say Mary is a delivery driver for UPS. She runs a red light, just like Mo did, and causes a car accident. And UPS has a policy that expressly forbids its drivers from running red lights and let's say tells them they have to follow all the rules of the road. Is that action, Mary's driving and making deliveries and running the red light, are those within the scope of employment? We might think, well, no, running a red light is not within the scope of employment. But this is a tricky one. the law would say, because Mary's driving of the delivery truck is a usual task that she would complete as part of her workday as a delivery driver for UPS, even the running of a red light is within the scope of employment because it's the same general nature of what she was doing, which is driving, which is what she was hired to do. So I want you to think with this one for a minute. Even running a red light or violating traffic laws is still within the scope of employment, and UPS as the principal would be liable. So again, we need two factors. We need employee and we need acting within the scope of employment. What about an example like this? Let's say it's an absolutely beautiful day and I'm driving my delivery truck and I'm following all the rules of the road, but I just decide I don't really feel like making deliveries. I think I'm just going to knock off and I'm going to drive the truck over to the beach and just enjoy the beautiful day. And then I'll hop back on my route later and my employer will never know. We call this one abandonment. Abandonment, it cuts off that liability. It means if the employee who was acting within the scope of employment abandons their work, takes a complete detour and starts engaging in their own business, then they're no longer acting within the scope of employment, even if they are still on the clock. Okay, so again, that's why I didn't want you to focus on what hour of the day it was. I want you to focus on what that employee or agent was hired to do, and are the actions they're taking within that same general task, which would be scope of employment, but not if the agent abandons their duty to start doing their own things. Once the employee starts to do that, then the principal would no longer be liable for the actions. So if I'm off at the beach and I decide to then, this is basically this example, if I'm at the beach and I get into a car accident then because I abandoned my duties for the day, my employer UPS would not be liable. All right. A couple other tricky examples is what about intentional torts? So this would be like assault and battery, like punching somebody at the workplace. That's a little different from negligence. Remember, negligence is like, slip and fall, like an employee tripping and spilling coffee on somebody accidentally. Intentional tort would go something like this. The delivery driver arrives at his customer's house, and instead of making the delivery, he rapes the customer. Or what if he really doesn't like the customer, and he punches them? Is the employer liable for those actions? You can see how different that is. This is a rule called negligent hiring or negligent supervision. An employer is not liable for the intentional torts of their agents, so like the rape or the assault, unless A, the employee was doing that on behalf of the employer, let's hope not, or B, the employer was negligent in hiring or supervising, meaning knew or should have known that it was likely that this employee or agent could have committed such a tort. So an example of this would be if the employer received complaints about a delivery driver acting inappropriately and kept saying, yeah, it's fine. I'm sure he's fine. I'm sure it's no big deal. And then at some point the employee attacks a customer. Well, then that employer is liable because he was negligent in supervising his employee. We actually saw a lot of these cases, in case you recall, a number of cases against the Catholic Church for assaults that priests were making on young boys. And the church kept moving those priests to other locations. That lawsuit was based in negligent hiring and negligent supervision because the church knew what was happening and didn't do anything to take actions. So they were liable in a civil case brought by the victims. So I wanted you to see how when it comes to torts, the way we treat negligent torts, like a car accident, is very different from the way we treat intentional torts. The last thing I wanted to mention is just what about the agent? An agent is always responsible for your own actions. If you're driving the delivery truck and you get into a car accident, you're still liable. You don't get to say, but I was driving it for my boss. You're always responsible for your own actions. Okay, that is the end of our section on agency law.